Hello, Assalamu alaikum. How are you all? So, you know that every time I'm so fascinated, I'm so delighted to share about the valuable experience and valuable comment on the legal issues. So, in that legal procedure, I'll discuss about the legal analysis of environmental governments in Bangladesh. So, what do you mean by the environmental government? Environmental government is on kind of way whether the environmental laws will be implemented so powerfully and purposefully. But the thing is that the common people of Bangladesh, they are not concerned about the environmental law, environmental jurisprudence, and the environmental satisfaction measurement. So in that criteria, the people can think that it is on kind of codified law or the documented law. But I don't think that environmental law has a huge amount of responsibility all over the world. Even Bangladesh is a developing country, but Bangladesh have to follow the environmental rules, regulations, and perspective for the future time also. Because Bangladesh right now in a problem of economic surveillance and the economic problem, but in the future time, Bangladesh has no types of single problem related to the environmental mechanism and environmental jurisprudence. So what will be happening in that time whenever we have enough capability to do so, but we have no types of environmental measurement or environmental mechanism in Bangladesh. So right now I'll discuss about the environmental mechanism. Environmental mechanism will be codified in three things. First of all, we have to maintain a very good law. Then we have to think that our law is codified, our law is justified, even our law is aligned with the expectation of the environmental jurisprudence and the environmental law. So in that perspective, our think is that environmental mechanism totally depend on the implementation program. For example, we have Water Act 2013, but we are not concerned about this matter of the Water Act 2013. It is not the codification, it is not the justification. We have to implement the environmental law despite lots of social problem, political problem, or the ecological problem. And that I have already mentioned, we have the ecological demanded problem and the principles in Bangladesh. So in that procedure, we have to give up from the strategy not only for our own development but also the development for the common perspective or the common society. So it is said that environmental entity is the holistic entity in Bangladesh. There is a basic reasons why the international scholars and the environmentalists are saying about this matter. I think that there is related the three things. First of all, environmental is the holistic entity which is directly driven by the Almighty itself. So Almighty definitely provide us the opportunity, but we have failed to enlarge our opportunity, to utilize our opportunity, even organize our opportunity. So this is some kind of basic burden for our common scholars and the legal scholars in reshaping the environmental jurisprudence in Bangladesh. The second reason, which is literally much more needed for the environmental governance and the environmental jurisprudence, this is our government is not so concerned in implementing the jurisprudence of environmental law. So a student can ask me a question, sir, what do you mean by the environmental jurisprudence? So I have to directly mention that Rio Declaration 1992 directly reshaped and codified as on kind of environmental jurisprudence in Bangladesh. Having lots of controversies in the environmental jurisprudence mechanism, our government, our scholars, even our panelists, they will discuss over the environmental jurisprudence, environmental literal meaning in the real sense. So it would have been better for the Bangladeshi government to follow the environmental mechanism directly. But in Bangladesh there is a problem. The basic problem is that you have, first of all, you have to certify the environmental convention. After that, the environmental convention will be raised by the parliamentarian. Whenever the parliamentarians say that it's actually been okay, so in that time environmental law will be implemented in Bangladesh, because Bangladesh is following the dualism theory of the international law and the international mechanism. I'm not the international scholar, but after observing the environmental jurisprudence, environmental mechanism in Bangladesh, I have to say that in Bangladesh, environmental jurisprudence has not been implemented yet. For example, we have polluter pays principle, we have environmental impact assessment principles, we have environmental jurisdiction, we have prior informed consent. So can you please ask this question to the High Court divisions advocate or the judges about this matter? They will say you that they are not okay, they are not concerned over this matter, because this is not their loophole. This is not the loopholes of the Bangladeshi segment, because we are not emphasized, we are not performed these types of social capabilities related to the environmental jurisprudence, environmental mechanism from the very beginning of our Environmental Conservation Act 1995. So it's actually a great thing that we made a new laws, Bangladesh Environmental Conservation Act 1995. But the thing is that Bangladesh Environmental Conservation Act 1995 has not directed most of the basic principles, useful principles of the environmental law. So how is it possible for the Bangladesh, including the NGOs, lawmakers, stakeholders, advocates, even the law teachers, to implement the environmental law directly? First of all, you have to implement the environmental law in the common perspective or the common sense. Whenever it is justified among the common stakeholders, it is known by the common people, then it is possible for the government to implement the environmental jurisprudence, reshaping the environmental future in Bangladesh. According to the Bratland Commission 1887, Bratland Commission demand is that we have to interpret the environmental psychology and the environmental jurisprudence on the demand of the sustainable development. Even sustainable development directly contradict with the basement of the environmental convention, because sustainable development origin from the famous case Gapchikovo Nagemaro's project case 1987's direction. And in the year 1987, at the same time, Sir Bratland occupied that our common future. Our common future is on kind of principles, whether the environmental principle and the environmental jurisprudence, it will be nullified in the same principle for protecting the environmental sustainability for the future perspective. And in that consequence, in that context, environmental jurisprudence has two contexts. First context is that it will be implemented for the present generation. Present generation means the generation which is existing right now in the universe. In addition, it will also implement for the future generation. Future generation means the generation will come in the future. That means they are the unborn person in the environmental psychology. So one of the directions of the New Zealand court has came that the unborn person has the right over the environmental principles and environmental convention. So as far as it possible, the concerned state, I mean the domestic state, they will try its level best for implementing the environmental jurisprudence, international convention, Rio Declaration, or more even the Stockholm Declaration, directly implement to this new state for implementing the environmental jurisprudence of the concerned state. So while I'm talking about the environmental principles in the context of the Bangladesh, then I have to mention that Bangladesh has definitely three problems. The first problem is that in Bangladesh, the people are not concerned about the environmental jurisprudence and the environmental psychology. Whenever you are not concerned about the environmental psychology or the environmental education, then how is it possible for the government to implement the environmental direction in Bangladesh? The second problem for Bangladesh is that Bangladesh is not directly followed the codified principles of Stockholm Declaration or the Rio Declaration. By following the Rio Declaration or the Stockholm Declaration, Bangladesh has made Bangladesh Environment Conservation in 1995, and after 2 years later, in the year 1997, Bangladesh has also occupied the new principles of the environmental jurisprudence. This is Bangladesh Environmental Rules 1997. So my question is that after existing the two basic principles of the environmental law and the environmental context, why the government has failed to implement the environmental mechanism in Bangladesh? My question is very crystal and clear that till 2020, Bangladesh has made 20 plus environmental related laws in Bangladesh, and very recently Bangladesh Parliament has passed a new law. The law's name is Bangladesh Maritime Zones Act 2019, but it has no impact on the environmental surveillance and the capability program, because people are not aware about the environmental jurisprudence and the environmental psychology. So first of all, my question is that you have to much more cautious about the development of the environmental education and the environmental psychology. Whenever you will cautious about the environmental jurisprudence, environmental psychology, in that time every principle has been applied without any kind of interpretation. So it might be better for the Bangladeshi government to directly implement the environmental rules and environmental phenomena from our neighbor country India and Pakistan, because India and Pakistan gesture and posture regarding to the environmental mechanism is very fine. So if Bangladesh would like to make a basic development on the environmental jurisprudence and principles, directly Bangladesh can follow the prior informed concept principle from the Indian judiciary, even public participation program from the Pakistan judiciary. Inherently, by implementing the environmental jurisprudence and environmental convocation in the perspective of Bangladesh, inherently Bangladesh has been made a basic development over this matter. From the Metro Makers case 2019, Bangladesh implement that every people will be liable for the polluter pays principle and the public participations. Whenever they have failed to implement these types of principles individually, they have to accountable for this measurement to the Honorable High Court Division. Even High Court Division has the authority to accountable the person, to question the person why he has been violated the environmental principles and the environmental jurisprudence. So I'm going to discuss over the implementation program of the environmental mechanism and the environmental success, but it doesn't mean environmental law will be implemented until our government is much more aware about this program. So I think that environmental mechanism will implement in the future time, unless the government does not make any kind of apathy over the environmental jurisprudence and the environmental certification. According to Bangladesh Blue Economy Act, Bangladeshi government has tried its level best for implementing the blue economy water resources activities in Bangladesh. But the literal meaning is that 90% of the people of Bangladesh, they are not concerned about the environmental mechanism and the environmental jurisprudence. So how is it possible for the Bangladeshi government to implement the environmental rules, justification, credibility, environmental form of legal jurisprudence and legal matters throughout the mechanism of environmental principles and the environmental mechanism? I believe that it is not possible for the Bangladeshi government, but it can be possible for the Bangladeshi government if Bangladeshi government can take the help of the common people, take the help of the NGOs, take the help of the other divisional activities to interpret these types of mechanism throughout the practice and conscience mechanism of the environmental mechanism. So I have to mention another criteria. According to Article 18A, Bangladesh Constitution directly says that Bangladesh government will directly apply the environmental mechanism and the environmental service mechanism through Article 18A of Bangladesh. So in that mechanism, Bangladesh government has mentioned a very good principles, biodiversity program. So biodiversity means a diversity of the biological insight and the components. So I will discuss about the biological components and the biological discourse in my next videos, but this is all about the implementation mechanism of the environmental rules, which is related for our economy and the economic conscience for the future perspective and time.